Penguin Random House Audio presents The Originalism Trap: How Extremists Stole the Constitution and How We the People Can Take It Back. This is the author, Madiba K. Dennie. To my mother, who knew I would write a book long before I did. We the people. Not we the white people. Not we the citizens or the legal voters. Not we the privileged class and excluding all other classes, but we the people, the men and women, the human inhabitants of the United States, do ordain and establish this Constitution. Frederick Douglass, Speech on the Dred Scott Decision, May 14, 1857. Preface. When I entered law school as a fresh-faced 20-year-old, I was convinced that law was the principal avenue through which rights were protected. But in both the classroom and from the world around me, I quickly learned that wasn't quite right. I spent long hours learning how the law works in theory, and then I would go home and grieve how the law works in practice. My academic career coincided with the evisceration of the Voting Rights Act, the acquittal of the man who killed Trayvon Martin, and the failure to indict the police officer who killed Michael Brown. A particularly astonishing departure from the course material suggestion that indictments are so easy to come by, a prosecutor could basically get a grand jury to indict a ham sandwich. I wanted to learn how to use the law, to fight for marginalized people, but I watched the law repeatedly fail people like me. So I had to refine and clarify my optimism. Law can be a critical avenue for protecting rights, if we make it so. This philosophy, requiring the use of the laws we have, fighting for better ones, and empowering other people to do the same, has guided me through my work as an attorney, columnist, and professor. Shaping legal thought and providing sharp, accessible analysis attuned to the needs of marginalized people is literally my job, and I don't pretend to be dispassionate about it. When you're a Black immigrant woman and a lawyer, and when you understand how the law is weaponized against Black people, immigrants, and women, among others, you feel a unique pain and a unique power. I'm both professionally and personally invested in radically reforming our socio-political and legal systems, and I can treat the Supreme Court's embrace of oppressive legal theories with the rigor and rage it deserves. I wrote this book because I believe that innovative legal analysis and public education are both necessary in order to achieve a multiracial democracy. People who are harmed by what the court is doing should be able to understand what the court is doing. People with and without access to the halls of power should be able to challenge those who would abuse that power and dress up plain old oppression in legal garb. Everyone should be able to make and defend the claim that rights and equal justice under law are for all of us. And so, the originalism trap is for all of us too. I sometimes asked myself, in frustrated moments a decade or so ago, what the point of my legal education was. You're listening to my answer. Chapter 1. Heist. Lawyers don't often admit this in mixed company, but I'll let you in on a secret about interpreting the Constitution. There is no one objective way to interpret the Constitution. If there were, what would be the point of judges? We could resolve legal disputes by simply inputting our claims and evidence into a computer that would output uniform rulings. We don't do that, though, because judging calls for, well, judgment. A classic hypothetical law can show you what I mean. Imagine a statute reading, "Vehicles are banned in the park." One would have no trouble discerning that such a law would be broken by an adult wantonly driving a sports car over the public's flower beds. But what about a child driving a toy convertible, or a tourist riding a motorized scooter, or a first responder driving an ambulance to an injured parkgoer? Whether those are vehicles within the meaning of the law's prohibition is debatable, so legal arbiters make judgment calls. Judgment is generally exercised in the American legal system through methods of constitutional interpretation. These methods tell us what should or shouldn't be considered in order to figure out a law's meaning. Judges need a fair and consistent way to determine what constitutional provisions mean and how to apply them in new and different cases. and legal interpretive method is a fancy way of saying there's a method to the madness. There's been considerable debate historically over what sources and analytical approaches form the best basis for judicial decision-making. Indeed, courts may and often do consider more than just one interpretive method in isolation. They call upon a variety of factors, including judicial precedent, what courts have done, historical practices, what people have done, and, of course, the text of the Constitution itself. But over the last 40 years or so, the conservative legal movement has been wildly successful at promoting the idea that originalism is the only legitimate way to interpret the Constitution. The originalist method ostensibly determines constitutionality by relying on the original public meaning of the Constitution at the time it was drafted. Circumstances may evolve, but the Constitution's meaning does not. Or, as former Supreme Court Justice and fierce originalist Antonin Scalia famously put it, it's not a living document. It's dead, dead, dead. The sales pitch for originalism goes a little like this. Originalism is objective. We can know authoritatively what the Constitution means, its supporters argue, by discovering what it meant to the public when it was adopted. And, some say, this is what the Constitution's ratifiers wanted. Former Solicitor General and one-time Supreme Court nominee Robert Bork once wrote that only the approach of original understanding meets the criteria that any theory of constitutional adjudication must meet in order to possess democratic legitimacy. Only that approach is consonant with the design of the American Republic. So, if you want to know what rights you have, originalism commands you to consult the time capsule. Its proponents contend that to do otherwise is to lawlessly substitute your own policy preferences for the wisdom of the Founding Fathers. However, ironically enough, historical evidence suggests the framers themselves did not want generations of Americans to be bound to their view of the document. Thomas Jefferson explicitly cautioned against excessive reverence of constitutions at the expense of societal progress, and further illuminated the absurdity by way of analogy. We might as well require a man to wear still the coat which fitted him when a boy, he wrote, as civilized society to remain ever under the regimen of their barbarous ancestors. Footnote: an eyebrow-raising suggestion that he was aware of his own barbarity, to be sure. From Proposals to Revise the Virginia Constitution, 1. Thomas Jefferson to Henry Tompkinson. Despite originalism's reputation as a serious intellectual theory, it's more like dream logic. It seems reasonable at first, but when you wake up, you can recognize it as nonsense. Originalism deliberately overemphasizes a particular version of history that treats the civil rights gains won over time as categorically suspect. The consequences of its embrace have been intentionally catastrophic for practically anyone who isn't a wealthy white man, aka the class of people with exclusive possession of political power at the time the Constitution's drafters originally put pen to paper, or quill to parchment. By treating the Constitution as dead, originalism deliberately entombs historically marginalized groups' legal claims to liberation. Which history matters? There are levels to the intellectual dishonesty. Sometimes history surprises us. Yes, there's a lot of bad, but it's not actually all bad all the time. The period of radical reform following the Civil War is particularly noteworthy here. During Reconstruction, as this time is called, the country constitutionalized the emancipation of enslaved people and created federal safeguards to both protect their newly recognized freedom and affirmatively foster legal equality nationwide. Mention this to originalists, though, and they're suddenly stricken with memory loss. The 13th, 14th, and 15th Amendments to the Constitution fundamentally changed the document for the better by dramatically expanding the socio-political community and, for the first time, seeking to build a multiracial democracy with equal membership for Black people and other marginalized persons. Footnote: obviously, they did not succeed, but never before had the government deigned to even try. The 13th Amendment formally abolished slavery, except as punishment for a crime. The 14th Amendment created birthright citizenship, forbade states from violating certain rights of citizens and non-citizens alike, more on this later, and prohibited states from denying any person equal protection of law, limited the political power of insurrectionists, empowered Congress to
Sample complete. Ready to continue?